We're sticking with issues of the Corruption and Financial Crime Cases Trial Monitoring Committee. Now, it's no longer news that the former president of the Court of Appeal, Justice Ayo Salami, has declined to head the committee. The Chief Justice of Nigeria subsequently picked a retired Justice of the Supreme Court, Honorable Justice Suleiman Galadima, as the new chairman of the committee. The committee was inaugurated on Thursday. Despite the inauguration, some lawyers still have issues with the composition of the committee, and some of them spoke to Law Weekly.
I really don't think lawyers should be on that panel at all. I think there should be retired judges and perhaps users of the process, and that they should then be the ones who actually go to the courts, sit as part of the audience, and that would be the way in which they would monitor the process. So I'm not comfortable with the composition of the panel as it is now. I think that it is open to, I wouldn't want to say bias, but there may be a feeling that if I or my firm has a matter before a court, and then I'm also part of a panel that is reviewing the way the courts are sitting, some judges may feel a bit intimidated, especially because some of the legal members, the lawyer members of the panel are senior lawyers. True, they are past presidents of the Bar Association, and therefore they are representing the bar. But they also have their own private legal practices. So I would rather that the committee be totally reconstituted such that there are no lawyers, no active lawyers on the panel at all.
I believe that the idea of setting up the committee is a very good one and it's quite commendable, so the CJ should be commended for that effort, because the truth is that if we need to stem the tide of corruption in the country, we need such kind of bodies or committees to monitor and give feedback to the appropriate quarters. So I think the committee is a very good idea. But in terms of the composition of the committee, I really don't feel very comfortable with the composition of the committee. I believe that in setting up such a very vital committee, the process for selecting the members has to be inclusive. Stakeholders needed to have been consulted, bar branches needed to have been consulted, judges needed to have been consulted before members are chosen to that committee. Because as far as I'm concerned, I see that committee as a level so powerful such that you can compare it to the Legal Practitioners Privileges Committee or the Disciplinary Committee of the NBA. And we all know that these are committees that need to have, before you can select members, they need to go through several forms of screening and vetting and all of that. So in terms of the composition, I, for one, the main fact that we didn't hear about it when they were about setting up the committee about the criteria for choosing membership, I feel that alone is not appropriate. This kind of committee should have been set very open, because there are a lot of individuals that should have been on that committee.
My challenge really is that the court has its primary role to adjudicate and make its findings. I have my doubts as to how this committee is going to interfere in that process. But maybe in the sense of having an overarching role, that is yet to see. Because at the end of the day, the judge is the master of his court, and he determines how he wants the case to progress. But as to whether the judiciary is a critical part of the corruption process, it certainly is. But let's see how the committee is supposed to work, because I personally do not understand the details yet. Are they overseeing what the judges are doing? Or at the end, is it before, is it after, or is it at the end of the adjudication process?
Even the idea of setting it up has already achieved some results. It will keep those people they are expected to check, it will keep them on their toes. What we have is to build confidence in the system. And you build confidence in the system when we have structure on ground that will check excesses in the system. So setting up the committee is a good pointer. More importantly, if you look at the individuals that have been chosen, they are people that cannot be bought. They have achieved success in their various careers, and I'm sure they don't want to soil their hands with this kind of appointment. More importantly, with the controversies that has greeted the appointment, they also will be very careful. They want to justify the confidence reposed in them by the CJN. In terms of doing their work, my opinion is that they should go about it discreetly without necessarily attracting attention. Because when you attract too much attention, you will not be able to reach the point. Because like people have said, that corruption fights back. So if they have that in mind, they will know that they have to be very discreet in going about it. They need to go down, not into only the sensational cases. There are so many cases that are solving out of compromise, out of so many other factors. So they should go down, start from the magistrate court and go to the high court, go to various states. They should not concentrate in Abuja or Lagos alone. They should go deep. By the time they make one or two cases as scapegoat, you'll be surprised that other people will fall in line.